Some people have bad parents. Some people have bad siblings. Some people have bad everything that is not worth it. I have a friend that most of the properties he has, none of his family know about it.
I said next of kin, I believe, is just like a kind of glorified emergency contact.
Okay, like, even if you are married and you have a wife, instead of giving them, instead of giving your wife, just give your kids and put a clause to it. Baba, if I die, if my kids are not up to 20, you can even put it that if they are not responsible, that they finish the university and do this and that, they are not entitled to any of my properties.
The topic is actually a very interesting topic because you see, this issue of next of kin is more of a might, and it's one of a might that a lot of us, majority of us, are key into. And because most of the official forms that we fill, there's always a provision of next of kin. So we fill it with this mindset that that position carries so much power, or it has some legal standing. But if you look at, if you are to discuss issue of next of kin from a legal perspective, from a person who has a legal mind about how things work, then you realize that next of kin is more of social relevance or relationship. Like Mr. Adetola said the other time, I think you used the word, he said, that is like emergency contact. Because legally speaking, next of kin has no legal basis. You see, there's nowhere you will fill a form and you submit a form, and because you feel somebody has next of kin, that person automatically has entitlement or has access to your whatever. So it's more of a social requirement for emergency contact legally. And interestingly, why I said it's an interesting topic is that this is a topic that has caused fight between husband and wife, father and children. Some people, so even siblings will be fighting. Oh, daddy used our last born as next of kin. The husband is fighting that the wife didn't use him as next of kin. The wife is fighting the husband has not used him as next of kin and all of that. But because most of us don't have the legal mind to even ask or to query what is even the effect of this next of kin. Is it that when I open a bank account and I fill the form and I put my wife or I put my son or my daughter, and so if anything happens to me, he or she automatically has access to my money in the bank? The answer is no. Like all the hypothetical cases that you have read out, the person that died and the real matter. You see, everything, before you can have access to a legal right, there are procedures. Somebody dies. He dies without a will. We call it, he died intestate. And when somebody died intestate, what are the procedures to have access to the property or money in bank for those people? So there are a lot of things. Basically, I will conclude by aligning with what Mr. Adetola said, that next of kin, for every intent and purpose, is just for social contact in case of emergency. So it's more of a liability than an asset. When your name is put as a next of kin, you are not to benefit the asset of the person. You are to take liability of the person. So in case the person falls sick, who are we to call to take him to the hospital, to take her to the hospital? In case the person is owing us some liabilities, something spoiled in his care, under his care and all of that, who do we call? Who do we lay hand on? Basically, that is what next of kin can be. So if you look at the legality, you see, the reason why I decided, in fact, I made it a point of it to come today so that we can better enlighten ourselves. Because like I said, you see, this might has stayed with us for too long. This might has stayed with us for so long that we need to disabuse our mind as learned people, as educated people, so that we can take a better decision, so that it doesn't cause a fight between husband and wife. You see, why a woman is supposed to be fighting for other things. A woman is fighting that her husband is not making her next of kin. When she is supposed to be fighting for other things. What is the legal relationship? What is the legal standing of my marriage? Is my marriage under the act? What is the benefit in my marriage under the act? and when my marriage is not under the act. These are things that a wife should be fighting. Not that, oh, my husband uses his mother or his sister as next of kin. So, like I said, we need to disabuse our mind. We need to understand the legal position of what the hula baloo about next of kin is all about, so that, because like I said, majority out there are still making that mistake because people believe, like I said, it's a thing that has lived, with us for so long, and people are still relying, thinking that it has so much, legality or legal benefit. But next of kin, strictly speaking, has no legal basis. If a man dies and he dies without a will, and the man is married under the act, that means that is to say he married legally in the marriage registry that all of us go to, and you have a marriage certificate and a register and all of that. There is a legal benefit. There's a legal benefit attached to that. Than somebody dies without a legal marriage and without a will, and somebody wants to claim because he or she is next of kin, is never going to happen. The person is never going to have access to that. So there are a lot of things attached to access to the property of a deceased person. Either the person dies without a will, or the person dies with a will, or the person has a next of kin or doesn't have a next of kin, and all of that. There are procedures for it to assess all of that. If you look at it, if a person dies, we have marriage under traditional marriage to the Islamic marriage, marriage that allows you to marry more than one wife. What is the position of the law? How do you assess the property or the assets of such person? And when somebody is also married under the act, what are the procedures? And if person dies with a will, what are the procedures to assess the probate, to have access to those property? But legally speaking, if I want to advise, what I will advise people to be more conscious about is, one, the moment you are growing and you are accumulating assets, the best thing you can do for yourself now and after you die is to have a will. The best thing that speaks and dictates how your asset and property goes, the best is a will. And now, if you die without a will, are you legally married? If you are legally married, your spouse, your succeeding spouse succeeds you. It succeeds you with all your property. But however, there's a administration of estate law of each state which dictates how such property estates are going to be managed, even though the person is married under the law. So those are the things, some of the procedures that guides access to property. And because I made reference to access to property because we attach next of kin to that. Because while we are all fighting for next of kin is because you think that, I'll be a beneficiary of his wealth. I will have access to his property or his document after he dies. So there are other areas that we can look at for if the question arises. Thank you.
So the question is, in a situation whereby someone dies and they came to read the will to the family. Now, after reading the will, it favors some over the other. They are not really cool with the will. Now, they are not doubting the authenticity of that will. Now, I know they do video will now. So then was written. So how the lawyer confirms that kind of will to the family?
Okay. That will take us to issue of will. Since we are talking about next of kin and we are now taking it to the legal aspect. Now, when you are talking about will, I want to educate all of us here today that will is not something you write in the corner of your bedroom and you put. Are you with us, Peju? Will is not something you write in the corner of your room or in the corner of your office and you open your drawer, you put it and you say you have written a will. That is not a will. For a proper will, there are procedures. In fact, I will tell you, all of us today, that nobody is capable of writing a will without the guidance of a lawyer, because there are technicalities to drafting will. When you are drafting a will, there are issues of, there are procedural issues. There are issues of administrators. There are number of administrators that you must have mandatorily. There are number of witnesses that you must have, and there's a way the witness must witness the will. And now, after all that have been done and the will has been properly drafted and properly witnessed, there's what we call deeping of the will. The deeping of the will is the registration of the will. Will must be registered. When a will is written and is put in your draft, it's not a will, because the will wouldn't have gone through what we call probate. Before a will can be legal, can be authenticated, it must be registered in the probate, which is called the deeping. So when a will is registered, the original copy of the will, about 4 copies, are registered and deep with the probate of the high court of whichever state you are. So once the person die and a lawyer comes forth to say, oh, I was a lawyer to this man or to this woman during his lifetime, this is the will he left behind, and he sends a notice to the family. Of course, I've read so many wills to deceased family. And when there is, will can be funny. That a will is written does not mean that your children must be beneficiary. We have seen people who wrote a will. The last will I read to a family at Oyo, the man was a professor. He will substantial part of his property to a university in Oyo, and other property should be used as a general hospital or something. And so there are people who wrote a will that the expected beneficiaries are not even listed in the will. So like going back to your question, that what of if the will is suspicious and the expected beneficiaries are not listed? Yes, there's what we call challenging a will. You can challenge a will. And don't forget, like I said, that once a will is registered in the probate, it becomes an instrument of the High Court. So the only court you can go to challenge such a will is the High Court. So you can challenge the will, challenge the authenticity, challenge the witness, the people that witness the will. You're right. You can even challenge the signature of the person that makes the will. That, oh, when my father was alive, this was not his regular signature. And so you can go on and on to challenge the will and establish. If you establish before a High Court judge, of course, it doesn't take 1 month, it doesn't take 2 months. It's a procedure, because you have to file a writ. You have to attach or attack the person that you are thinking that compromised the will, because they will be the defendant. So of course they will also be given the opportunity to defend that. So, but if those procedures is followed, and at the end of the day the court realize that there is falsification or there is possible compromise, of course the High Court has the power to invalidate that will and subject the asset of that person to a person that dies without a will. But it's an Herculean task, I must tell you.
What if the lawyer dies before the person that owns the will?
Thank you. You see, thank you. You see, that's why I said a will is not something you write and you put on inside your cupboard. Once a will is registered, it outlives the lawyer, it outlives the owner, the deceased. You see, what happens when a lawyer dies, or sometimes somebody even die and people don't even know the lawyer. You don't even know maybe your father died and you don't even know the lawyer is lawyer in his lifetime, but you suspect that this man must have a will. It just takes you to suspect that my father must have a will or this person must have a will. So what we do is we do what we call search. So I can search without knowing the lawyer of Mr. Adegboju. I can go and conduct a search at the probate registry of Oyo State. I'm looking for the will of Mr. So I will pay the prescribed fee, and they will allow me. If I search through Oyo State probate and they say that I just have, I can move to Lagos State, I can move to Abuja, I can move to any place I think he could have registered his will. So if after conducting your search, you realize you didn't see any will, then you accept that he must probably not have will. But if in your search you realize, of course, it's a public document, they will tell you he has a will and they will give you a will number. So anybody, you can instruct a new lawyer to go ahead and write a letter. What the lawyer just need to do is to write a letter to the family saying that we have conducted a search, we have realized that Mr. So person has a will during his lifetime. We are suggesting so date for the reading of the will. So of course some of the family members will come around, you read the will. Anybody that is not satisfied with the will can go to the High Court and challenge it. So that is the procedure.
Basically, for me, I think this next of kin thingy is complicated in a way, because number one, I think our next of kin should be person wey dey for you. You might have a sister, you might have a dad, you might have a mother that has not done anything significant for you to give them or give them that importance or being your next of kin. Which means if na this lady wey dey beside me, she's my friend and we are close and she's more useful to me than anybody I have around me, why can't she be my next of kin? If I know that the things I'm living for her, that she's going to use it the right way. Some people have bad parents, some people have bad siblings, some people have bad everything that is not worth it. I have a friend that most of the properties he has, none of his family know about it. 100. Àwọn tó máa need the people,
the kind of parents,
it's about, some people might not even appreciate. They might be wishing you bad, they might not enjoy or they might not appreciate what you're having. So it's better for you to give people who you know that this thing will be of more value to them, rather than just giving your people that they don't have or that don't even wish you well, or when you are down or they don't even turn up or try to help you. So that's by the side. Now, even if you are married and you have a wife, instead of giving your wife, just give your kids and put a clause to it. Baba, if I die, if my kids are not up to 20, you can even put it that if they are not responsible, that they finish the university and do this and that, they are not entitled to any of my properties. People do that a lot. So what is stopping us from doing it? My own, let's forget, like the law said, let's wait for maybe the lawyer to conclude on how it is on paper. But on the street, me, I will tell you without stress that person wey dey for you, na him should be your next of kin. Kalas.
I said next of kin, I believe, is just like a kind of glorified emergency contact. So I think the only part the next of kin has is to delay any process. That's what I think. So I think it's just very important that people, whether the wife is bad or good right now, as long as there's no will stating anything, the bad wife can still get access to the property. Just like I think the lawyer said, that everything is just a legal matter at the end of the day. You understand? So yes, I believe whoever the person decides to make his or her next of kin, it's based on their own intuition. I don't think the person can be judged for that. But then it's just a glorified emergency contact. After the back and forth in the court, I believe they will have to do they will do the necessaries. The children cannot suffer. They can't suffer.
Okay, so we learn every day, and I agree with what he's now said about glorified, and even when he now backed it up. While you were also talking, I just let me even Google, and I saw that there's actually something called pay on debt, pay on debt beneficiary, right? I'm personally, for the first time, I'm just seeing it for the first time. So that's 200 million, 500 million you have your account. If you have that pay on debt beneficiary, then that means next of kin automatically useless. So my question now to you is, this person with 200 million has a will, right? Has a will and also has this pay on debt beneficiary in the bank. Which one is more superior? Yeah.
Let me just explain that pay on debt. The pay on debt is just an instruction given to you. Your banker is your errand person. And to every money, to every asset you have in the bank, you can give an instruction on how to do it. You can pay on debt. Is a way to circumvent the issue of next of kin, the problem that next of kin we encounter, and to actually circumvent some procedures. So it's an instruction given to your banker that in the eventuality of my debt, pay this person. Now, when you give a bank such an instruction, what the bank needs to verify before carry out is, of course, the person has to produce your death certificate and the basic things that establish that you are dead. And once that is confirmed, the bank can go ahead and carry out that instruction, because you have actually given that instruction, ahead of time. So it's just as simple as that. And it's a style that is even common in the Western world. Our people has not really, but it doesn't mean that we cannot. Because if you go to your bank, reason why I said it is not too common here is that even if you go to a bank now and say, oh, my bank, I want to give this instruction. I'm dropping this post-dated, I'm dropping a check or whatever instrument, in the banking instrument they want to use. I'm giving you an instruction to pay on my debt. I can bet you some of our banks will still have problems with it. You know, but it's a procedure that is common, you know, in the Western world. So it's a simple instruction to your bank, and of course you can instruct your bank. You know, there are people who give instruction to their bank without going to the bank every month. Pays also pays. So pays, you know, you can give such instruction. So it's just same thing. And I think that clarifies the issue of the money, or how superior that is to next of kin. Like we have read to will. Okay, to will. Yeah, yes, you know, will, you know, we call will a testament. And why we call will a testament is that it is the only document that speaks when you are dead. All right, so will does not become effective until you are dead. And now, if you have given your bank an instruction, they pay after death, to pay on death instruction. If you are the one that has done your will, that has made your will, of course, that instruction should not be conflict, should not be at variance with the position of your will, because that's why your will can be updated up to 20 times. And that's why we tell people, when we say prepare your will, it doesn't mean that the day you prepare your will, you will die. You can prepare your will 50 years ahead of your death. And the reason is that you have opportunity to update your will regularly. Oh, it is one land you had before when you made your will. Now you have acquired 10 lands. You can, update it. So that's why when you see will, when you are writing will, you see the last testament of Mr. So. So because there could be various previous. All right. So you can update your will as the time requires, and to cater for the instruction you have also given to your bank. Thank you. We just want to try to educate ourselves a little. Damaris has asked question bordering on will and LA. Yeah, basically, both documents are legal document that speaks about properties of a deceased. However, there are two different documents. A will is what is contentiously written, what you deliberately write down on how you want your property to be administered after your death. And like I've explained the procedure of writing a will and how to register a will. Now, if after registering a will and the person is late, like I said, what you get from the court is a probate. Now, where does LA comes in? What is LA? LA is letter of administration. LA is the document you process when the person dies without a will. All right. So you can't have a will and have an LA at the same time. No. Once a person had a will during his lifetime, it is registered and you get a probate. So once that person is late and the probate is gotten, like I said, in the will have stated the executors of the will. So the executors are going to be the one to sign to annihilate the property to a third party. Now, when somebody dies without a will, now the family process what we call LA. The LA too has a procedure. You fill a form, you go for interviews. We call them administrators of the LA. And so the administrator too has to be 2 or 4. So you process it, you pay estate duty, you follow the procedure. Then once the LA comes out, the LA becomes the legal instrument upon which you can sell property. Yes, of the deceased. So, and it is the name of the people in the LA as the administrator that can sign, that can sell. All right. So why it is the name of the executors in the will that can sell? So that's just the two different. The LA and probate and will, they are two separate. Once the moment you have a will, you don't require an LA. The moment you don't have a will, then they process the LA. So that's just the explanation.
The family gave maybe let's say an order to sell the property like
of
that,
a dead person without an LA.
Without an
There's likely to be a problem, because the question will be on what authority is the family instructing the agent can help you to market and all of that, but when it comes to instrument of the law, instrument of annihilation, the deed of assignment, so the question will be, who are the assigners? Who has the legal right? The agent does not have the legal right to say You know, so that's why even if you bring a property you want to sell, and like Damiris now want to buy property, and you said you give him the document, and you said the person is late to.
But most of the family used to give the agent maybe
A photocopy.
No agreement between them that
The power of attorney.
Power
Power of attorney, you cannot. You see, when you're talking about annihilation of property, there are instrument, legal instrument that you can use to annihilate property. A power of attorney is just an instruction. Except, there are places in the times past, in 1916 and 1970, there are times you use power of attorney to annihilate property, but the law is to the effect. The law now is that you cannot use power of attorney to annihilate property.